Okay, thanks for the introduction, Kyle. And this is a ballot issue it's kind of the hot ballot issue in Colorado this year on the ballot. And it's Proposition HH. I wanted to give this talk because my clients, my focus is local government law, and I am the town attorney of Town of Timnath and represent probably a dozen other special districts in the state, water districts, and metropolitan districts. So you'll hear a couple of examples about how this applies to my clients. So I knew I needed to learn HH. And so I thought this will force me to learn HH and maybe save you guys from having to read the legislation because it really is pretty complicated. So my hope is to try to make this a little easier to understand to help you know how you want to vote and also how it's going to implicate your future, your clients in the future if this does pass. Okay. So we'll start with just talking about what this is. So Proposition HH is a statewide ballot issue. So it's going to be on all the ballots in the state for this general election on November 7th, 2023. It was referred to voters by the state legislature in a 48-page bill. And that is the one I'm trying to save you guys from having to read because it takes hours to read. And it was passed on the last day of the legislative session. This was introduced very quickly. From introduction to passage was only 7 days. And so I think everybody, in terms of interest groups, was scrambling to try to understand what the implication of this was before it was passed. The ballot question, and actually on the day it was signed by the governor, there was a lawsuit filed challenging the ballot issue, which we'll discuss a little bit later in this presentation. So the ballot issue is one sentence. Shall the state reduce property taxes for homes and businesses, expanding property tax relief for seniors, and backfill counties, water districts, fire districts, ambulance and hospital districts, and other local governments, and fund school districts by using a portion of the state surplus up to the Proposition HH cap as defined in this measure? This has been characterized by the governor and the state Democrats as a property tax decrease bill. And if you go back to the language, it starts by, shall the state reduce property taxes? This is really a wolf in sheep's clothing a little bit because it does a lot more than just have a property tax increase. In fact, over the 10 years and into the future, it could even be a property tax increase, though we don't know. It would depend what the state would plan to do legislatively if this wasn't passed. So it's supported by Colorado Democratic Party, the Governor Polis, the Denver Post has endorsed it, AARP because of some senior tax relief, League of Women Voters, AFL-CIO, and the Colorado Education Association because of extra funds going to schools. But there are winners and losers in terms of who gets more money if this proposition passes. So if you look at who's opposing it, it's the Colorado Municipal League, the Special District Association of Colorado, and Colorado Counties, Inc., which are all statewide organizations that represent those classifications of local governments. Also, National Federation of Independent Business and Colorado Association of Realtors. I could not find that the GOP on their website had taken an official position, but I believe that the Republicans also oppose this generally. Okay, so to understand what the impact of this is, I wanted to run through really quickly how property taxes are calculated to begin with so that you can help understand what the changes actually are accomplishing. And so first of all, every property, let's say a residential property, but residential or commercial has an actual value that is the estimated market value determined by the county assessor based on prior sales prior to the tax year. So they take the actual value, then multiply it by an assessment rate, which is different per class and classification and type of property. So agricultural, residential, non-residential, multifamily residential. And that gets you to the assessed valuation of the property. And then the assessed valuation is multiplied by a mill levy rate to determine how much you owe. And the mill levy rate is set by all of the local governments that impose taxes. So there's no statewide property tax, but there are county property taxes. There are municipal property taxes if you're in a municipality. And then you might also be in a fire district. You might be in an ambulance district. You might be in a water and sanitation district. or a library district, and each of these overlay on top of each other. So they each set their mill levy rate to determine the amount of money they'll have available. And then you add those all together to determine the mill levy rate on the property. 1 mil is 0.1% or $1 per $1,000 of assessed valuation. So if someone says, they've got a 50 mil levy, then that's 0.05%. I'm doing my math right. And so for an example, if you had a $500,000 home, and I took last year's tax rate of the 6.9%, that was the assessment rate for single family residential property last year, then that gets you to 34,750. If you had 100 mills of all of these governments added on to each other, including school district, which I don't think I mentioned, and that might get you to owing $3,475 over the course of the year. And now I use the 2022 rate because we do not know yet what the 2023 rate will be. It depends on whether Proposition HH passes. Property taxes are assessed in arrears. So when we talk about the 2022 taxes, that's what you paid this year in 2023. When we talk about the 2023 taxes, they'll be set in December or January, and that's what you'll pay in 2024. Okay, so how did we get here? Again, I just need a little bit of background to help you understand what the status quo is. You can understand what is being proposed to be changed. So we had the Gallagher Amendment in effect for many years. It was a voter-approved amendment to the Colorado Constitution approved in 1982, and it was in effect until 2020. And at that time, what it did is it froze the total amount of property taxes being collected statewide for residential property compared to the total amount being collected for non-residential property, and made those ratios fixed. So what happened in practice was that the commercial assessment rate was 29% when Gallagher was adopted in 1982, and it stayed at 29%. But as the proportion of residential property value increased in comparison to non-residential property, the residential rate dropped every 2 years, and it's reassessed by the state the assessment rate is reset by the state every 2 years and recalculated, and was under Gallagher. Actually, I think it was reassessed. I'm sorry, it was reassessed every year, and so it kept reducing until it got all the way down to 7.15%. So in 1982, residential property, you took the actual value, you multiplied it by 21%, and then by 2020, you took the actual value, multiplied it by 7.15%. So the rate, the amount actually paid by residential property compared to commercial property for taxes continually decreased. But Gallagher Amendment has been repealed, so it's no longer in effect. This was repealed in 2020 by Amendment B, passed by the Colorado voters. So we no longer have automatic adjustments. This leaves the assessment rate in the discretion of the state legislature to set the statewide assessment rate for each classification of property. Now let's come along to 2001, 2002, when property values in the state increased in a dramatic rate. Actually, Boulder, I was surprised to learn, was one of the lower increases, increasing only by 35% in 2023. But according to DOLA, the Division of Local Government, then counties like Park, Eagle, Summit, Grand, and Lake counties saw increases by 62 to 67% of the actual value of the properties. And Pitkin averaged an increase of 92% increase in the actual value of residential property. So that was a little complicated. Let me break that down again. The county assessor reassesses the actual market value of residential property every 2 years. 2023 was one of those years when they reassessed, and the change that was implemented from 2021, when it was last set, to 2023 was this huge increase, 35% on average in Boulder County for residential property, to 92% for Pickens County. Well, that means if the assessment rate remained the same and the mill levies remain the same, taxes are going to go up by that percentage. So statewide, this caused a lot of consternation. If you're on Facebook, if you're on Nextdoor, you're probably seeing people really concerned when they got their assessment bills about what their taxes are going to do. So Proposition HH was passed in the 7-day rush at the end of the legislative session, mostly as a reaction to this large increase in the actual values of residential property, with constituents screaming, "Give us some help, state." Okay. Before we had Proposition HH in 2022, the state legislature already addressed this somewhat, knowing that these increases were coming and knowing now that the assessment rate is set as a legislative matter. So they passed Senate Bill 2022-238, and these are the current assessment rates if Proposition HH does not pass, because this has already been passed by the state legislature. So what they did is they said, for every residential property, we're going to take that actual value, say $500,000, and subtract off $15,000. We'll kind of give you almost like a credit before we even apply the assessment rate. Then they also said, we're going to reduce the assessment rate for residential property. We're going to take it from that 7.15 down to a temporary reduction of 6.765. So that would allow the state to go back up. I'm sure they need to in the future, but and reset it. So they set the assessment rates for 2023 and 2024. And then they also reduced other assessment rates for other classes of property. So you'll see most residential property classes were reduced for 2023 from 29% to 27.9%. And that's something that wasn't possible under Gallagher, because we had to keep the commercial or non-residential rate fixed at 29%. So it does give some property tax relief to both residential and non-residential properties. And then for the 2024 year, there was a temporary reduction again, and a little bit different rates. So for multifamily, it was 6.8 instead of 6.765. And then there was a formula to be used to calculate what the rate would be for other residential property, and then further reduced agriculture and renewable energy property assessment rate to 26.4%. Okay, so to break this down into components, I think it's helpful. This is the exact language of the ballot question. Again, I'm going to read it to you like 3 times. So sorry for that in advance. I know you guys can read. But there's 4 main topics that are mentioned in the ballot question. Now, whether they're actually different subjects or related subjects, that's a different debate we're going to talk about a little bit later. But what it says is, shall the state, 1, reduce property taxes for home and business, 2, expand property tax relief for seniors, 3, backfill counties, water districts, fire districts, ambulance, hospital districts, and other local governments, and 4, fund the school district by using a portion of the state surplus up to the Proposition HH cap. So let's look at these one at a time. Number 1, shall the state reduce property taxes for home and businesses? And this chart is a really helpful chart. Is from the fiscal impact report, which is put out for each bill by the non-political legislative council staff. So they are not Republican leaning or Democratic leaning. They are trying to analyze the fiscal impact of this. And I find this chart very helpful. So it talks about what the difference is. So everyone, promotes this as this big property tax decrease. But what you're looking at is, if you compare the current rates to the proposed rates, there's not much of a decrease. So for primary residential property, the assessment rate decreases from 6.76% to 6.7%. Okay, so that's a 0.065% decrease. It's a decrease, but it's not like a multiple percentage decrease. And in 2024, it might be a little larger of a decrease, but we're not quite sure what rate would be in effect in 2024 because it hasn't been calculated yet. And then for other multifamily, again, kind of similar reduction between 0.5% and 1%. The other thing it does is we talked about that 15% reduction in the actual value before you apply the assessed valuation. And that is increased from $15,000 to a $50,000 reduction for single family property in 2023 or multifamily property. And then in 2024, increase again from the 15,000 to 40,000 for senior owner occupied primary residence. That's where you get the big change, because once you get to 2025 to 2023, the reduction is $140,000 a year. Okay. Non-residential rates kind of did the same thing, about a 0.5% decrease. So there's some decrease, but, and, certainly adds up statewide, but in terms of your impact on individual properties, there is a property tax calculator on the State Department of Revenue's website. So you can see what your change would be to your individual property. But there, the commercial rates are generally changing from 27.9% to 27.85%. So there's a small change. Okay, the second thing that the ballot issue question language, which is all that's going to be on the ballot that the voters are going to see, is says that, shall the state expand property tax relief for seniors? So what this does is absolutely that's a part of this Proposition HH. And, I'll say that this was all Proposition HH for the most part was adopted pursuant to Senate Bill 23303. And then most of that bill, that 48-page bill, was contingent on voters passing this Proposition HH. So I do put in here the statutory side of where this is going to be codified should Proposition HH pass. But the biggest change that it does is that it increases the credit for senior owner-occupied properties from 2025 through 2033 to $140,000. So you have that $500,000 house, you subtract $140,000 before you multiply the assessment rate on it. It also extends what's classified as owner-occupied qualified senior primary residence. And so that if you had a homestead exemption as a senior and you move to a new house, you can receive the same benefits. The next thing that it does, number 3, shall the state backfill counties, water districts, fire districts, ambulance, hospital districts, and other local governments. And so this one is where the TABOR excess that the state's allowed to keep comes in. And so if you've heard any of the media about this, I'm sure you're hearing that in addition to a property tax reduction, this is also allowing the state to keep TABOR surplus. So the Taxpayer Bill of Rights, adopted in 1992, is a constitutional amendment. Article 5, Section 20 of the Colorado Constitution, and it puts in place a revenue limit on state revenue that says, we'll actually have the exact language a little bit later, but basically limits the state revenue to what you collected last year plus a CPI increase, then accepting a few things that weren't applicable. And this one now increases that limit. So the excess TABOR limits that the state would be allowed to keep, excess TABOR funds, are first used to backfill the local governments that lost revenue because of the tax credits we just discussed, up to the maximum amount that's available in that fund, which in the first year would be $240 million. In second years, would probably be less in subsequent years. Now, this is only backfilling taxes for general operating purposes because if, say, a fire district has issued bonds to pay for a new fire station, they can still assess what they need to. So they would just increase the rate to be able to collect more money to then be able to pay for that fire station bond. And so we're really talking about general obligation financing. And fire districts are one of the ones that are most hit by this, because if you think about it, fire districts don't send a bill to their constituents. There's no water and sewer service where there's a general bill. So they're mostly financed by taxes. And so they are going to be hit if there's a reduction in the assessment rate, and the fire district happens to be mostly residential. So there will be an impact on them. But the backfill ends if basically the local government has an increase of 20% or more in the assessed valuation. So this is going to phase out for most governments because of these large increases in assessed valuation statewide. They're going to kind of offset the reduction that's from the assessment rate reduction and the credit. So these are going to phase out. They will last a little bit longer for the ambulance, fire protection, and health service districts, which are the ones that are more reliant on this operating tax basis as opposed to fees. Okay. It's a pretty complicated formula, though, to figure out how much to backfill. It depends on the size of the county, depends on how much their property tax assessment rate was reduced. Okay. Let's see. Here's how we get to the state being allowed to keep extra money. So the TABOR limits state fiscal year spending to the percentage change in state population for the last year, adjusted for revenue changes approved by voters. And so, you know what, I misspoke when I said CPI. For state, it's actually based on that population change rather than CPI. So what they do is they take how much the state spent last year, minus certain exceptions, like enterprises are exempted. And then they multiply that by the percentage in state population, and that's the total amount of spending for the next year. The state has not waived that limit statewide. This is the closest we're getting to that. So the Proposition HH, if passed, would now allow the state to retain money above that TABOR limit by basically adjusting the TABOR, taking the amount they collected for last year, adjusting it by inflation plus 1%. And so what they're going to be doing is, and the change in state population. So every year they'll be able to go a little bit higher above that TABOR revenue limit of what it prior was. And those are cumulative. So it's 1 year, then it's 1 year past the second year will be 1% greater than the 1% increase in the first year. Okay. So this new money is put into a newly established fund. And then it is used to for three purposes. First, for this backfilling of these state and these local governments, and that applies to counties, special districts, municipalities that are not home rule municipalities, and it exempts home rule municipalities, and it exempts school districts. Okay, then secondly, after they've paid the ones that are qualified up to the maximum, they provide renter insurance. There's a renter's assistance program that will get 5% of the surplus up to $20 million. And then if there's more, everything else goes to the state education fund. So the Denver Post projected that this would increase the state's budget by about $170 million this year and up to $2.2 million per year in a decade. And that's because of that inflationary, where you're increasing it by an additional 1% each year, matching up what that limit is. Okay, the 1% increase each year is in effect until 2032. After that, the state has to determine whether they're going to keep increasing that Proposition HH limit, but they are authorized to do so without an additional voter approval versus TABOR would typically require voter approval anytime you wanted to go over that limit. Okay, so number 4 in the ballot question is, shall state schools be the state school fund be increased through the surplus? And absolutely it is. But first, we're also increasing the funding to the Housing Development Grant Fund, which is nowhere mentioned in the ballot question. So after backfilling the local government, then the extra, what they define as state surplus funds, so the difference between the prior TABOR limit and this new Proposition HH limit, will be used up to 5% or $20 million to go to the Housing Development Grant Fund that reduces the amount of property taxes paid as a portion of tenants' rent, thinking that this is going to be, most of this property tax increase will be passed through to tenants and will actually impact them. And then any excesses goes to the state education fund. If you remember, the Colorado Education Association was one of the proponents of this because there is a huge increase in state education funding. And the bill talks about that will not replace general appropriations to state education. But there's more. Oh, wait, there's more. So on the same day that the state legislature passed 33303, and there's 23303, it also adopted House Bill 231311, which says this bill only goes into effect if Proposition HH passes. And it changes the method for calculating TABOR refund calculations and distributing them in 2023. So how are TABOR refunds done right now? The state has played with how they give their refunds back in the last few years. So this chart shows how they have done their refunds in the last few years. So there was a, so at one point there was an income tax reduction that's going to go away with Proposition HH, and instead it's or even with the existing 233238, and instead that reduction is going to go into backfilling the local governments. So that's how that goes. And then the second thing is that there is a tax deduction, and that is changing how the tax Proposition HH would change how the tax deduction works. So right now, when you file taxes, the amount of deduction for the TABOR refund would be based on your income level, and the change would be a pro rata amount. So basically, if you made under $99,000 a year, then you're going to get more TABOR refund if Proposition HH passes. And if you make more than $99,000, you will get less TABOR refund if Proposition HH passes. Okay, and wait, there's even more. Proposition HH also creates a new fiscal limit applicable to all local governments other than school districts and home rule municipalities, and home rule counties, of which there's 2, and cities and counties, which is its own category. Okay, so since they represent local governments, this is one that we're watching carefully because it changes how we're going to pass our budgets this year. So there are currently 2 limitations on revenue for local governments. The first one is a statutory limit that we call the 5.5% limit. And this is the property tax that you've collected cannot be increased by more than 5.5% a year. And there are exceptions into this doesn't apply to any taxes for voter approved debt. This only applies to taxes for general operating purposes. The other thing we do is there's exemptions, like if property was omitted and then is added to the tax bill, that's accepted. There's also the TABOR limit, which is actually 2 limits. One is the limit on the annual percentage growth in and they define local district. That would also include a municipality. It's defined pretty broadly, so it includes a lot of local governments. So the maximum change in the fiscal year spending equals inflation for the prior year plus annual growth adjusted for revenue changes approved by the voters. The second limit is a limit on the amount of property tax revenue you can collect, and it's limited based on the amount of property tax you collected the prior year, increased by inflation, plus annual growth. And annual growth means new construction within the boundaries of the local government. So if you have a house that's scraped and rebuilt for 3 times the value, that increase from the lower value house to the higher value property house is not included in the increase you can have. So you can have that increase, and then in addition, you can have this increase that's based on CPI, that's based on the percentage change in the area. And okay, so when we as local governments are trying to set our mill levy, our tax rate for each year, what we need to do is we have to calculate, first of all, the 5.5% limit, and then we have to calculate the TABOR limits. And then whichever limit is less and is more restrictive is the limit that applies to the local governments. So what this might mean is that your mill levy rate might have to decrease. So if you certified 10 mills, and then you had a huge increase in property assessed valuation like we did last year, when you calculate your limits, you might have to drop it to 8 mills. And so that's the actual impact of the 2 limitations we have right now. But most of the local governments in the state have waived both of the limits. The only way to waive these is by voter approval. And I put in some ballot language for one of the districts I represent. This was ballot language that was on the ballot in 2020 and did pass. It said, without creating any new tax or increasing tax rates, unless separately approved by the voter, shall Colorado City Metropolitan District be authorized to retain and spend all revenues it receives from all sources fiscal year 2020 and thereafter as a voter-approved revenue change and an exemption to the limits that would otherwise apply under Article 10, Section 20 of the Colorado Constitution, TABOR, the 5.5% limit in 29.1.301, or any other law. So, I last put together the calculations in 2020. These might have changed a little bit, but as of 2020, 51 out of the 64 counties in the state had waived these limits for both the 5.5% and the TABOR limits. 230 out of 274 municipalities had their voters waive these limits, and 174 school districts had waived the limits. We call this de-Brucing colloquially, and that's because Douglas Bruce was the main impetus behind TABOR. And this is a way to waive some of the TABOR limitations. It does not waive all of the limitations of TABOR. So voters are still required to approve any new tax or tax rate increase, or to approve any long-term multi-fiscal year obligation that's paid out of taxes or that's paid out of revenue other than an enterprise revenue, which is accepted. So de-Brucing does not, we call it de-Brucing because of Douglas Bruce, and it's getting out of some of the requirements that Douglas Bruce put into the state constitution, or, encouraged to be put into the state constitution. It does not waive all of the limitations under TABOR. Well, this new limitation under HH would apply even to de-Bruced governments, because the voters would have waived the limits before this new limitation comes into place. And the new limitation now says that your property tax revenue starting in 2020, for property tax 2023, which will be shown in the budget for 2024, cannot be increased by more than inflation unless the local should not be increased by basically more than the rate of inflation. And that's defined as the Denver Aurora Lakewood CPI. Now, there are exceptions again. So this is going to be a calculated formula that for each local government, since this is a new limitation, we're going to have to figure out what's accepted, what's included. For instance, oil and gas revenue and mining taxes are exempt. Taxes that are imposed to pay bonds are exempt, or mill levy rates that are approved by the voters after Proposition HH election would be also accepted. And new construction again would be accepted from this. Now, so if Proposition HH passes, every local government in the state, other than the home rule municipalities and the school districts, is going to be struggling and scrambling to figure out what this new limitation is and how it applies. But it can be waived. So it's not actually a limitation. It's more of an administrative procedure that we now all have to follow. Thank you, state legislature, for more big government and more red tape that we need to follow. So the limitation can be waived if notice is published in a newspaper and posted on the district's website before they adopt the proposed mill levy, at least 10 days in advance, and they hold a public hearing. Now, the notice has to have certain specific provisions and talk about what the mill levy rate is going to be. And then there's, requirements that obviously you have to let the public speak for a reasonable period of time and try not to limit the comments unnecessarily. And then you pass a resolution or ordinance approving the mill levy. So as a practical matter, if you want to exceed this limitation, you just have to follow the procedure. And if you don't, then there is a requirement to refund that excess back to your taxpayers in the following year. But if you were in a jurisdiction that was following this very closely, that said, we're not gonna, we don't want you to go over the Proposition HH limit, where the community really turned out, there's a possibility that this could be more of a definitive limitation just due to political reasons if there was a lot of public uproar. Okay, now there's more. I'm sorry. This is better than reviewing the whole bill, I promise you. So there's other limitations that aren't mentioned at all in these four, and they are mentioned in this ballot language. So Proposition HH also creates new subclassifications of property for assessment purposes, like a renewable energy agricultural property and the owner-occupied primary residences and the qualified senior primary residences. It also adds a new definition of primary residence real property and makes a working group to try to make recommendations to the Division of Property Taxation as to how to streamline and improve the definition of primary residential real property. And so if you are a land use attorney, this is going to be really important to follow and understand how this is going to work, because in order to qualify for the new senior exemption or the primary residence real property exemption, you have to file an application with your county assessor containing certain information. Also, it changes the deadline for budgets for local governments. And again, local government attorneys are scrambling. So now you see why the Colorado Municipal League, the Colorado Counties, and the Special District Association are actually in opposition to Proposition HH, because it creates a lot of uncertainty for us. In addition to creating this new limitation, it changes all of the deadlines. So typically, a county has to tell us what our assessed valuation is by December 10th, 2023. So we get a preliminary certified assessed valuation in October that says, okay, district, we think your total assessed valuation in your district is about $5 million. And then the district can say, okay, well, for our budget, we need, $50,000 in taxes. Let's do the math and figure out what the mill levy rate would be. Well, then they go and certify a final assessed valuation in December. Usually we get that by December 10th, and then we can finalize our budget. This, if Proposition HH passes, gives the county assessors up until December 29th to certify that final assessed valuation. We are hoping they don't take that long. Actually, the county assessor in Boulder has been awesome and has given all of the, I represent about five special districts in Boulder, 4 or 5, and has given them an estimate of what we think the limits are going to be if this passes. So that's really helpful. Now, the preliminary to final is going to always change somewhat because, for instance, you have everyone who appeals their assessed valuation. So that final number is always going to mostly decrease a little bit, but with HH, it would decrease even further. Then typically the deadline is December 15th for this local government, special district, municipality, to certify what mills they want to collect to the county assessor. Now the deadline has changed back to January 15th. So what you're going to have is you might have boards scrambling to meet between the 29th and January 5th, or at least the attorney is doing, work over years to recalculate what, and the accountants to recalculate what the new limits are going to be and what the new mill levies are going to be. Then, so typically the deadline to hold the public hearing and appropriate funds was December 15th. Those would be extended to January 5th. And the deadline for the county to certify their mill levies was December 22nd, moved back to January 12th. So this just means, all the local, be very thankful to your local government officials, because they're all going to be scrambling if this passes to figure out what this means and figure out what this means for their budget for next year. All right. So I mentioned early on that this was challenged on the day that the governor signed it. There were 12 counties that joined this litigation in addition to other entities. And so this was kind of a combined challenge that was first went to the district court and then went straight up to the Colorado Supreme Court. And they challenged Proposition HH on two bases. The first one was that this actually violated the single subject requirement. So when you have either a referendum or an initiative where a ballot issue is put to the voters, it is to only include one requirement. That's to make it clear so that, if there's one subject, if there's too many subjects, voters might be in favor of one subject and against another subject. And also it creates confusion. So that was the first basis for the challenge, and the court did not rule on the substance of that. The district court conditionally ruled on the substance because this was, everybody wanted to get this resolved before the November election, and there was a big rush. So in the district court, they said, we want opening and answer briefs on the same day. And they did the same in the Colorado Supreme Court, and they really expedited the review of this. So they expedited so much that the district court said, you know what, we're going to rule on the subject matter jurisdiction thing, but we're also going to say, if we're wrong, and the Colorado Supreme Court says we're wrong, we're going to opine on what the merits of this would be. But that decision never really went into effect. And then the Supreme Court did make their changes based on the Supreme Court did rule on the subject matter jurisdiction issue as to the single subject requirement. And what they ruled was that they did not have single subject. They did not have jurisdiction to review this question until it was passed by the voters. So we have to put it to the voters, and then we can expect litigation afterwards to later challenge this on the single subject basis. We talked about all of the things encompassed under this bill. I think there's a legitimate argument that it might encompass more than one subject. Absolutely. They all relate to property taxes, but beyond that, there's a lot included in here. Now it is an uphill battle, even for a single subject challenge, that there's a presumption that the legislation approved by the voters is valid. So it is an uphill battle for someone wanting to challenge this. The second basis for the challenge was the clear expression. And both of these are based on, if you look in the left on this slide, the constitutional provision that says no bill shall be passed containing more than one subject, which shall be clearly expressed in its title. So single subject, clear expression. The courts did rule on the merit of the clear expression because they said if it is not clearly expressed, we could order that the language be modified before it's put to voters. So there was a remedy that they could address to clear expression, and they found that Proposition HH was clearly expressed. So the petitioners had claimed it wasn't clearly expressed in a few reasons. First, lack of detail about property reductions. And the court said, you don't need that much detail. You can't possibly put all of the detail into a ballot question. So there's a lot of discretion in the amount of detail that's put into the ballot question. And generally, we're not going to find it's unclear because of lack of detail. It needs to notify the voters as to what the topic is. And, voters can do their own research as you're doing here today. Secondly, there's no referendum, or there's no mention of House Bill 23-1311, which is the one I mentioned that if Proposition HH passes, 1311 goes into effect. If it doesn't go into effect. And that's the one that changes how the TABOR refunds are given to residential property owners taxpayers in 2023. It also doesn't mention the appropriations for rental assistance. There's other things it doesn't mention, as we talked about. And the court said that's okay too. So it can't possibly mention everything. So, as long as it's clear as to what it's mentioning. Finally, they challenged that it was using confusing and obfuscating language, such as state surplus. And the thought that was that by using state surplus, people didn't really know that that was a TABOR overage, that it's commonly referred to as a TABOR overage, not a state surplus. The court said, no, not unduly confusing. And finally, there's no mention of the new funding for the state education fund, which exceeds revenue to be lost from the property taxes. So, wasn't as clear on this TABOR limitation and the new TABOR reduction in the TABOR limit on an ongoing basis for the state TABOR limit to be funded for education. Okay, where are we? So anyway, these holdings basically led us to, this is going forward to the ballot. We can expect another challenge afterwards based on the single subject rule. It's actually a really fascinating decision. There's a lot there. Recap. Here's the ballot question again. I told you I was going to show you this 3 times. This is what it says. What it doesn't say is it allows the state to keep the TABOR surplus. It mentions it. It says that some surplus will go to the education fund, but doesn't really talk about what that is. It doesn't talk about creating a new limit for local governments. It does not talk about new subclassifications for assessment purposes, the housing fund grant, and the change in the budget deadlines for 2023. So if all the voter does is read this, they're not going to know all of the implications of this ballot question. That's it. I threw a ton of stuff at you. I'm sorry. And I would like to answer some questions you have, or at least try. I'm going to tell you, we're all trying to understand what this means because it has come into, it's going to come up so frequently. Colorado, purplish on Colorado Colorado Public Radio described this as an onion, layer after layer after layer of what the actual impacts of this are going to be. So from a general perspective, I'm not crazy about throwing a ballot question at voters that they're going to have such a hard time understanding, but that's me personally. All right, I'm open to questions. Kyle, do you want to moderate some questions?
Hi, Carolyn. I'm happy to do so. People can also unmute themselves if they prefer to do that. I can tell you 2 questions came into the chat while you were speaking, Carolyn, both from Robin Byers. The first question was, what happens to the current senior exemption if HH passes, aside from making the 10-year requirement portable? And then the second question was, are library districts also exempted?
Library districts. Okay, so it's by exempted, no, they're not. They are included, so they would be subject to this new cap, and they would have to go through the public hearing to exceed the new cap limit. They also would be subject to the backfilling, and the changes in their deadlines for certifying their budget. So all this would apply to a library district. That was the easier question. The second question, you might need to do a little more research on this, but I think that this almost replaces the existing senior homestead credit, but that's not my main area of expertise. So somebody on the line might even know more about that than I do, but it really creates this new definition. So I think they're going to be processed this way instead, but I might be wrong about that.
Nice. Again, this is Kyle. Those are the only chat questions thus far. But again, everyone's
Okay.
welcome to chime in to either answer that question or ask their own. So please feel free.
Hey, Kyle, this is Luis Tovar with Cottonwood Water. I have a quick question. Carolyn, on if you can tell us a little bit more about this backfill, because my understanding is that there is within the backfill entities that qualify for that money, there is a further layer of that onion that needs to be peeled, right? My understanding is that the 80% of that bucket will go first to a specific group, and then the remaining to another specific group. Is that a true statement?
Only if there's not enough money to fill all of the districts. So first of all, in the first year for 2023, the bucket is $240 million. If that's enough to backfill all of the districts, then they will all be backfilled to the rate that is calculated. However, if we're short either in that year or in a future year, then yes, there's a preference to the hospital districts, the fire districts, and the ambulance districts that would be backfilled first. There might be one more, but those are the three that come to mind. So they do get backfilled, and then the others are pro rata decreased in what their backfill amounts are. So the formula is complicated because they differentiate between whether you're in a county of over 300,000 residents or under 300,000 residents. And the percentage of backfill is different, larger for the small county districts and the larger county districts. And then they look at once your assessed valuation has led to has increased by 20%, then the backfill actually terminates, which is something that most districts are going to get to pretty quickly, I think.
Gotcha. So essentially, just to touch base on the last piece you just said, if you are under that 20% increase, that automatically qualifies you for this backfill pod,
Yep.
if you will.
Yep.
Okay, great. Thank you.
You're welcome. Great question. I hope I didn't confuse you guys entirely, but
well, I guess I'll ask you the next question because
go for it.
I have a long list, but I'm going to try to manage your time and the rest of the group here. But so when we're talking about districts that operate on a mill levy, right? Mm-hmm. Could you tell us a little bit about how this difference in between collected taxes from the previous year times this index, right? Mm-hmm. And the way I understand what you're saying here is that if for some reason that math appears to be that you're collecting in 2023, of course, next year, if that new collection exceeds that formula, then you have to go through this administrative path to essentially do a public hearing before you actually get to approving your budget. In other words, you have to open the floor, tell your community, hey, listen, we have this increase, but our expenses still exceed last year's collection plus the index. Does that make any? Am I kind of explaining the question well here for you?
Yes, that was very well phrased. So first of all, a local government, their tax rate has to be approved by voters at some point under TABOR. So TABOR was enacted in 1992. So if a local government had taxes already in place in 1992, they could continue to impose tax at that same rate. Couldn't increase it without a new TABOR increase. So some districts just, they're certifying at the same mill levy rate that they have been all the way back to 92. Others have voter approval of what their mill levy rate can be that they've run through to voters and referred to voters since after 1992. So you've got your mill levy rate, and then that if voters have approved it or it's in effect since 1992, you can keep imposing the taxes at that same mill levy rate. So we're not talking about the rate. What we're talking about is the amount of money that's collected from that rate. And if your voters have approved a waiver of the otherwise TABOR limit, there's still a new limit put in place. You do have to go through another public hearing process. So you're going to see on the agendas of local governments, there'll be a public hearing on the budget, a public hearing maybe to set rates for water and sewer rates or something. There might be, and that's not the statutory requirement to have a public hearing on rates, but many do. And then you'll have a separate public hearing on whether to exceed the Proposition HH limit. And so some local governments are making the decision not to even ask for that, to reduce their mill levy rate so that the total amount they're collected is under that new limit. And HH actually says you can do a temporary mill levy rate reduction so that you're not exceeding that new collection limit. But you could still go back up to that maximum amount that was either what you imposed in 1992 or what your voters approved in a future year should assessed valuations drop. So that is, and you know, that's, so there's several factors, but it's also, yes, if local government wants to exceed that, they just need to go through the public hearing and resolution process. So it'll be a new resolution as well to exceed the Proposition HH limit in addition to your typical budget and appropriation resolutions.
Carolyn?
Yeah,
Thank you.
Hi, can you hear me? This is Paul McCormick.
I can.
So this is obviously well out of my wheelhouse, but I want to get back to your cartoon about a wolf in sheep's clothing. It sounds to me, if you reduce this down to its basics, that there may be a reduction in taxes, but there may be a concomitant reduction in TABOR refunds. In the final balance, does it make a lot of difference, or is it a wolf in sheep's clothing?
I think in the final, I mean, we can't predict what that TABOR refund would be in future years because we're not going to know what the CPI is going to be in future years. So we're projecting based on anything, but I'm not sure it's going to be a property tax decrease overall. I'm absolutely not sure about that. Because it's decreasing it by this 0.5%, and then this 2-year decrease in residential property for the $50,000 and $40,000 credit, if you will. But it's a 10-year. Allowing the state to keep more TABOR revenue for 10 years. And that can be extended by the state legislature without a future vote. So if you were to really do the analysis, I mean, we won't know until 10 years from now, but I'm not at all convinced it will actually be a property tax. Well, it would be a property tax decrease, but it may also, it would also decrease the credit that you get on your income taxes. So is it overall a reduction to the taxpayers? I'm not sure. The other thing is that, remember, the state legislature can do this without a vote. So the only reason they need to take this to a vote under TABOR is because of keeping the TABOR limit. And because to exceed that TABOR limit, it must be approved by voters. So the main reason, one of the main reasons I think that they refer this is to allow them to exceed that TABOR limit and put that funds into school funding. Now, we all like schools, so that's a good reason, but they could have done all of the property tax reductions just by legislation. So in Senate Bill 22-238, they reduced the rates and they gave a credit per home. So they could have again reduced the rates again and given a credit per home without referring this to the voters.
Thank you.
Sure.
Kyle, do I have time to ask a question?
Absolutely. You're welcome to stay
stay.
on as long as you're willing to. It's up to Carolyn.
Okay.
Yeah.
Great. Hey, Carolyn, it's Harmon. Thanks so much. You did not confuse me. I thought you illuminated this issue really well, and it is confusing. It is 48 pages of legislation, so thank you.
You're welcome.
So just one quick comment. This with the reductions being absolute numbers, it's one of the areas where you can use an absolute number and it's actually not regressive. It's progressive because it benefits people with lower property values proportionally more than it does people with higher property values. You know, a 40% reduction on a $4 million home doesn't do much, but it does a lot on a $400,000 home. So anyway, I think that, you know, the question is, do you think that it's a two-part question. Do you think there are decent bones to this that if it passes, you know, might justify the passage? So I know you're essentially against it. And the second part is a basic question on how we deal with legislation, which I'm embarrassed to say I don't know the answer to. Once an initiative passes like this by a vote of the people, can the legislature tinker with it, or is it locked in because it was passed by a vote of the people?
Two questions. Okay, so first of all, I will say I'm not necessarily opposed to this. I'm probably leaning towards voting for it, but I have not decided. And the reason is because I understand it gives more money to school districts. I just don't think it's clear what it tries to do. And it does create extra work and paperwork for my clients and headaches. But you know, the other way it's progressive is that this TABOR refund is now a pro rata as opposed to a larger refund for individuals with higher income levels. So both of those are pro rata changes. So yeah, I'm still trying to decide how to vote on this one, but okay, so
the second question was just about, you know, if they wanted to tinker with it, let's say property values continue to go up, can the legislature tinker with it? Can they increase the exempt portion? Can they change the rates without sending it back to the people because this was originally a vote of the people, or is it locked in its current form?
Little bit of each. If I recall correctly, without looking it up, I think you have to wait a year to change something that's been passed by initiative. But at that point, it, you know, later on could be because it's a statutory amendment rather than a constitutional amendment. But I think if they wanted to give an additional reduction, I don't see anything, even if though it was passed by voters, from preventing them from doing that, you know. So they could pass separate legislation that says we're putting another $10,000 per property reduction on the property. And you know, so I think there's ways you could craft the legislation. It'd be difficult to increase the rates, but if you were reducing them, I think that is possible.
Thank you.
Yeah.
Well, and Carolyn, that might be it. So if you're able to, what I can do is if anyone has any questions they think of, you know, 5 or 10 minutes from now, I can always get those to Carolyn and she can respond that way.
No problem. Yeah, I'd be happy to be patient with me if it takes a couple days to get back to you, but and follow up if I don't get back to you. But I'd love to talk about this. And there's just, it's like an onion. There's a lot of layers. So I also encourage you to read the Blue Book, which is 12 pages on this ballot issue, which again tells you how complicated it is. And then the state fiscal report, the Legislative Council fiscal report, is also, you know, pretty fascinating. So there's a lot of information available from public sources.
Great. And what I can try to do to everyone is send out the links to those in the when I send out the CLE form. So I'll make sure those links are included in that CLE that I send out either later today or first thing tomorrow morning. But thank you, Carolyn. This was really good. Even I could follow, and I don't know what I'm talking about.
Oh, I'm glad it wasn't. I'm like, oh, now I'm really getting into the weeds on nerdy government tax law, but you know, I'm glad.
Perfect.
Thank you.
Excellent. Everyone's saying they appreciate it. Very helpful info. So thank you again, Carolyn. And thank you all for joining us today. I'll get out that info as soon as I can. Have a great weekend, everyone.
Thanks. Bye.
Bye.